I think this is very important here because we want to be clear in what the Supreme Court weighed in on. The Supreme Court was taking up this central question about whether a lower court judge has the ability to block this part of the president's policy and his agenda. The Supreme Court was not weighing in on the particular question of whether the president's push to end birthright citizenship is constitutional. And so what the Supreme Court does decide here is that they do clear this path for the president to move forward with plans to try to end birthright citizenship in this country. And this does have broader implications here because we know this is just one of many issues that lower court district judges have weighed in on. They've weighed in on a series of things when it comes to immigration, not just birthright citizenship.
All right, so I need to explain something that happened at the Supreme Court because the headlines are making this sound like a huge win for Trump, but the reality is way more complicated and actually kind of devastating for his administration if you understand what really went down. The court ruled 6-3 in a case called Trump versus Casa, and yes, they did limit universal injunctions, which sounds like a victory for the White House. But here is what nobody is talking about. They also kept the blocks on Trump's birthright citizenship executive order in place while sending everything back to lower courts for more litigation. So Trump gets a procedural win on paper while his actual policy remains frozen and his legal problems keep multiplying. This is the kind of decision that both sides can claim as a victory, but when you look at what it actually means on the ground, the administration is still stuck unable to implement one of their signature immigration initiatives. But before we go any further, real quick, let's be honest. You can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us. Be part of the community that actually cares about the truth. All right, let's get back to the video. Let me break down what universal injunctions are because understanding this is crucial to understanding why this case matters so much. When a federal judge blocks a government policy, they can do it in different ways. They can say, this policy cannot be enforced against the specific people who sued. That is called party-specific relief. Or they can say this policy cannot be enforced against anyone, anywhere in the country. That is a universal injunction, also called a nationwide injunction.
Good morning, I'm Wade Johnson in New York. We're coming on the air because the Supreme Court has just released a potential landmark decision impacting the future of birthright citizenship in the U.S. The justices were asked to roll back nationwide injunctions against the president's attempt to redefine the 14th Amendment, which states that anyone born in the U.S. is automatically a U.S. citizen regardless of their parents' citizenship status. It's been in place for more than 150 years. But now, in a 6-3 split, the conservative majority ruled that President Trump can move forward with implementing his birthright citizenship.
These universal injunctions have become incredibly powerful tools for blocking executive actions because one judge in one district can stop an entire national policy dead in its tracks with a single ruling. The Trump administration has been running into universal injunctions constantly throughout this second term. Lower court judges keep looking at various executive orders and saying, no, you cannot do this, and you cannot do it anywhere, not just in my district. The birthright citizenship order has been blocked since February. Immigration enforcement orders have been blocked. Agency restructuring has been blocked. Over and over again, federal judges have been issuing these sweeping nationwide orders that freeze administration policies before they can even be implemented, and the administration has been furious about it, arguing that one judge should not be able to override the entire executive branch. So the Supreme Court took up this question of universal injunctions in the Casa case and ruled that lower courts were being too broad. They vacated 4 universal injunctions as overbroad, meaning they went too far in their scope. They said courts should issue narrower relief that applies to the specific plaintiffs or classes of plaintiffs rather than blocking policies nationwide. On the surface, that sounds like exactly what Trump wanted. It sounds like the court is reining in judges who have been blocking his agenda, and his supporters are definitely spinning it that way on social media and in friendly media outlets. But here is where it gets interesting and where the administration's problems actually get worse in some ways. The court did not say the underlying policies were legal. They did not give Trump the green light to implement the birthright citizenship order or any of the other blocked orders. They just said the relief was too broad and sent everything back to lower courts to figure out a narrower way to block the policies. So now, instead of having one universal injunction blocking the birthright citizenship order nationwide, you are going to have multiple class action lawsuits and multiple courts all reaching the same conclusion that the policy is unconstitutional. The blocking continues. It just takes a different legal form. And the merits challenges, the actual arguments about whether these policies are constitutional, those are all still alive and pending. The Supreme Court specifically preserved those challenges, so Trump still has to defend the birthright citizenship order on the merits. He still has to explain how an executive order can override the 14th Amendment, which pretty clearly says anyone born in the United States is a citizen. Legal scholars across the political spectrum have said this order is almost certainly unconstitutional, and now Trump has to litigate that question through the full court process rather than hoping the Supreme Court would just make it all go away. The dissent in this case is worth paying attention to, too. Justice Kagan wrote that the majority's approach risks leaving executive overreach unchecked. She warned about the consequences of limiting how courts can respond to illegal executive actions. When one of the liberal justices is sounding alarms about authoritarian overreach, you should listen, because they see things from inside the institution that the rest of us do not get to see. The dissent suggests that at least some justices are deeply concerned about the pattern of behavior from this administration and worried that procedural changes like limiting universal injunctions will make it harder to stop illegal conduct. The shadow docket statistics tell an even more interesting story about what is really happening at the Supreme Court. There have been 23 shadow docket rulings on Trump administration matters through October of this year. 20 of those have been favorable to the administration. Only 3 have gone against them. So yes, the court is generally helping Trump when it comes to emergency procedural matters. But even with that favorable treatment, the administration keeps losing on the substance. They win the procedural skirmishes while losing the actual war over whether their policies are legal. That pattern is not sustainable, and it is not the vindication Trump pretends it is. All right, so let us really dig into what this Supreme Court decision means and why it matters for the broader fight over Trump's immigration agenda and executive power more generally, because this is one of those cases where the legal details really matter and where the political spin from both sides obscures what is actually happening. The truth is more complicated than either Trump claiming total victory or his critics claiming total defeat. The truth is that everyone is kind of losing here while the constitutional questions remain unresolved and the policy chaos continues. First, let us talk about the birthright citizenship executive order, because that is what this whole case is really about. Trump signed an order attempting to end automatic citizenship for children born in the United States to undocumented parents. This was one of his big campaign promises and one of the most controversial actions of his second term. The problem is that the 14th Amendment to the Constitution says pretty clearly, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. That language has been interpreted for over a century to mean that anyone born on American soil is automatically a citizen regardless of their parents' immigration status. Legal scholars have been nearly unanimous in saying Trump's executive order cannot override a constitutional amendment. You cannot change the Constitution with an executive order. That is not how any of this works. If you want to change birthright citizenship, you need a constitutional amendment which requires 2/3 of Congress and 3/4 of state legislatures. Or you need the Supreme Court to fundamentally reinterpret the 14th Amendment in a way that contradicts over 100 years of precedent. Neither of those things is going to happen anytime soon. So the executive order was always on shaky legal ground from the moment Trump signed it. Lower courts recognized this immediately. Federal judges blocked the order starting in February, and those blocks have remained in place ever since. The administration appealed and fought and complained, but they could not get the policy implemented because judges kept saying it was obviously unconstitutional. And not just liberal judges, judges across the ideological spectrum looked at this order and said there is no way this passes constitutional muster. The 14th Amendment says what it says. You cannot executive order your way around it. So the administration came up with a different strategy. Instead of defending the policy on the merits, which they kept losing, they attacked the procedural mechanism courts were using to block it. They argued that universal injunctions were improper and that courts should not be able to issue nationwide blocks on executive actions. This was a clever legal play because even if they could not win on the substance, they might be able to limit how effectively courts could stop them. If each lawsuit only protected the specific plaintiffs who brought it, then the administration could implement the policy everywhere else while fighting case by case. The Supreme Court gave them a partial victory on this procedural question. They agreed that universal injunctions are often overbroad and that courts should generally limit relief to the parties before them. They vacated 4 specific universal injunctions and sent the cases back to lower courts with instructions to issue narrower relief. This is a real win for the administration on the procedural question. It does make it harder for one judge in one district to stop a nationwide policy with a single ruling. But here is what the administration did not get, and this is crucial. They did not get permission to implement the birthright citizenship order. They did not get a ruling that the order is constitutional. They did not get the lower court decisions overturned on the merits. All the legal challenges to the order remain alive. The blocks remain in effect, just in a different form. Instead of one universal injunction, you now have the potential for multiple class action lawsuits that collectively block the policy everywhere it would be applied. The practical effect is similar, even if the legal mechanism is different. The merits review that is ongoing is where this really matters. The Supreme Court has agreed to hear arguments about whether the birthright citizenship order is actually constitutional. That case is coming, and it is going to be the real test. And based on everything legal experts have said about the 14th Amendment, the administration is likely to lose that case badly. The text of the amendment is clear. The precedent is clear. The history is clear. You cannot end birthright citizenship with an executive order. When the court finally rules on the merits, that order is almost certainly going to be struck down permanently. What the administration won here is time and the ability to make their opponents fight harder for the same outcome. They can now argue that each lawsuit has to establish class certification and go through additional procedural steps before blocking the policy. That adds delay and complexity to the legal process, but it does not change the fundamental problem. The policy is almost certainly unconstitutional, and no amount of procedural maneuvering is going to fix that. The shadow docket pattern is worth examining more closely because it reveals something important about how the Supreme Court is handling Trump administration cases. The shadow docket refers to emergency orders and procedural decisions that happen outside the normal briefing and argument process. These rulings often come quickly with little explanation and no oral argument. 23 times this year, the court has issued shadow docket rulings on Trump administration matters. 20 of those went in the administration's favor. That sounds like the court is firmly in Trump's corner. But look at what those favorable rulings actually do. They mostly involve procedural matters, staying lower court orders temporarily, limiting the scope of injunctions, allowing certain actions to proceed while litigation continues. They do not decide the ultimate legal questions. They do not say Trump's policies are constitutional. They just manage the process while the real decisions get made elsewhere. The 3 rulings against the administration have been on more substantive matters where the court actually engaged with the merits. That pattern suggests the court is willing to help Trump procedurally while being more skeptical about the substance of his claims. Justice Kagan's dissent in the CASA case raised important concerns about what happens when you limit courts' ability to block illegal executive action. She warned that the majority's approach could leave executive overreach unchecked by making it too difficult to get effective relief. She also flagged concerns about agency cases where political considerations might improperly influence hiring and firing decisions. The dissent reads like a warning that the court's conservative majority is too willing to defer to executive power in ways that could have dangerous long-term consequences for constitutional governance. The cabinet infighting over legal strategy that reports mention is another sign that things are not going well internally. When an administration is winning its legal battles, you do not see reports of cabinet members fighting over strategy. You see that kind of infighting when things are going badly and people are looking for someone to blame. The legal strategy of attacking universal injunctions rather than defending policies on the merits has won some procedural battles, but it has not actually gotten any of the blocked policies implemented. And now the administration faces the prospect of defending the birthright citizenship order on the merits before a Supreme Court that has shown some willingness to check executive overreach. Okay, so let us break this down into the key points you need to understand about this Supreme Court decision and what it means for the Trump administration's legal position going forward, because this story is more complicated than either side wants to admit, and the implications are going to play out over months of additional litigation and political fighting. Point number 1, Ryan, the administration won a procedural victory, but not a substantive one, and that distinction matters enormously for what actually happens to their policies. Yes, the Supreme Court limited universal injunctions. Yes, they vacated 4 sweeping lower court orders. Yes, this makes it technically harder for one judge to block a policy nationwide, but the birthright citizenship order is still blocked. The immigration enforcement orders are still being challenged. The legal problems have not gone away, they have just changed form. Winning on procedure while losing on substance is not actually winning. It is just delaying the inevitable while making the process more complicated for everyone involved. The practical effect of this ruling is that instead of fighting one big lawsuit, the administration now has to fight many smaller ones that collectively achieve the same result. Every affected group can bring their own challenge. Every class action can seek certification. Every district court can issue its own ruling. And all of those rulings are going to say the same thing, and that Trump's birthright citizenship order violates the 14th Amendment. The blocking continues, it just comes in a different package. The administration has not solved its fundamental problem, which is that their policy is almost certainly unconstitutional. Point number 2, the merits review that is coming is going to be devastating for the administration, and no amount of procedural maneuvering can prevent it. The Supreme Court has agreed to hear the challenge to the birthright citizenship order on the merits. That means they are going to actually decide whether the order is constitutional. And based on everything legal experts have said, conservative and liberal alike, the order is going to lose. The 14th Amendment says what it says. Over 100 years of precedent says what it says. You cannot override a constitutional provision with an executive order. When that ruling comes down, it will not just block the policy temporarily, it will strike it down permanently. This is why the procedural victories ring hollow. Even if the administration wins every single procedural fight along the way, they still have to win on the merits eventually. And on the merits, they are almost certainly going to lose. All they have done is delay that loss while creating additional chaos and uncertainty in the meantime. The people affected by these policies remain in limbo. The courts remain clogged with litigation. The constitutional questions remain unresolved. None of that is good for anyone except lawyers who bill by the hour. Point number 3. The shadow docket statistics reveal that the Supreme Court is helping Trump procedurally while remaining skeptical about substance, and that gap is going to matter more as these cases develop. 20 favorable shadow docket rulings out of 23 sounds impressive. But those favorable rulings are mostly about process, staying injunctions temporarily and limiting relief while cases proceed. The 3 unfavorable rulings have been on more substantive matters. That pattern suggests the court is willing to give the administration rope procedurally, but is not going to bail them out when it comes to the actual legal questions. Justice Kagan's dissent warning about unchecked executive overreach is important to take seriously. She sees the court's procedural moves as enabling behavior that threatens constitutional norms. She is worried that limiting courts' remedial powers will make it too hard to stop illegal executive actions. And she is flagging specific concerns about politicization of government agencies that echo criticisms from across the political spectrum. When a Supreme Court justice writes a dissent that reads like a warning about creeping authoritarianism, you should pay attention, regardless of your political views. Point number 4. This decision feeds into the broader pattern of administration legal problems that are accumulating faster than they can resolve them. Congress is killing executive orders through appropriations. Over 150 orders have been blocked by various courts. Judges are finding contempt for defying court orders. And now even the Supreme Court victories are partial at best. The administration keeps claiming they are winning, but their policies remain blocked and their legal exposure keeps growing. That is not what winning looks like, no matter how you spin it. The connection to cabinet infighting is telling. When things are going well, you do not see reports of senior officials fighting over strategy. You see that kind of chaos when the strategy is not working and people are looking for someone to blame. The decision to focus on attacking universal injunctions rather than defending policies on substance was a calculated legal choice. It has produced some procedural wins, but it has not actually gotten any blocked policies implemented. And now the administration faces merits review on their flagship immigration order, knowing they are almost certainly going to lose. That is not a good strategic position to be in. What should you watch for going forward? First, watch the merits case on birthright citizenship when it gets argued at the Supreme Court. That ruling will be definitive one way or another, and most experts expect it to go against the administration badly. Second, watch how lower courts respond to the direction to issue narrower relief. Will they find ways to effectively block the policies through class actions and other mechanisms? Almost certainly yes. Third, watch for more shadow docket action as the administration tries to get temporary wins while avoiding definitive losses. And fourth, watch the political fallout as Democrats use these legal battles to argue that Trump is lawless and out of control. The larger point here is that the Supreme Court is not going to save the Trump administration from its own legal overreach. They might help procedurally, they might narrow how courts can block policies, but they are not going to rubber stamp unconstitutional executive orders just because Trump wants them to. Even this conservative court has limits, and the birthright citizenship order appears to be beyond those limits. When the merits ruling comes down and the order gets struck down permanently, all the procedural victories in the world will not matter. The policy will be dead, and the administration will have wasted enormous resources fighting a battle they were always going to lose. This story continues to develop as the legal process plays out. There will be more rulings and more appeals and more political drama, but the fundamental trajectory seems clear. The administration is losing the legal war even as they win occasional procedural battles. And that dynamic is only going to intensify as more cases reach the merit stage and as courts increasingly lose patience with an administration that keeps trying to implement policies that have been declared unconstitutional. Stay tuned, because the big decisions are still coming, and they are going to matter a lot more than these procedural skirmishes.